Hello everyone, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, last week, the city of Edmonds got a big old stick it from our Washington State Supreme Court when they unanimously, that's right, unanimously struck down Edmonds' rather oppressive and unconstitutional safe storage laws. Well, I had an opportunity to go back and kind of trace the history on this, and we're going to do a little video today about how the city of Edmonds wasted taxpayer dollars on gun control. Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click that like button. If you want to stay up to date on issues related to your Second Amendment right, go ahead and click that subscribe button. Click the little bell logo if you want to be notified when we post new videos. And most importantly, let's keep the comments and discussions coming. I really want to hear what you all have to think about this issue here. Okay, Dateline last week, as we know, in the matter of Bass v. City of Edmonds, your Washington State Supreme Court struck down Edmonds' safe storage law by a vote of 9-0. That's right, every single justice struck it down. Now, I had an opportunity, I got a little curious here. I mean, it's not often you see 9-0 decisions in favor of gun owners coming out of the Washington State Supreme Court, so I thought to myself, how freaking obvious must this issue have been? So I went back and I decided to trace the history of how this all came to be. And I got to tell you, if you're a resident of the city of Edmonds, you should demand some tax dollars back, because when you see this history, you're going to see that your city council, your city attorney wasted a tremendous amount of money throwing rocks at the moon. This ordinance was dead from the get-go. Everybody who could read the law would have known that, and yet they continued on and on and on at the taxpayer's expense. So let's go back to 2018. As we know, there was a terrible, terrible school shooting at the Marysville Pilchuck School, not far from Edmonds, and then Mayor Mike Nelson took it upon himself to save lives and immediately pushed for a new safe storage ordinance that would apply only to the citizens of Edmonds. Now, at the same time, Initiative 1639 was kicking around and was picking up steam, and so that ultimately became law. And as we know, there are now laws which are codified in RCW 9.41.360, which places penalties and liability upon us if we neglect or fail to secure our firearms. But there is nothing in that law, 941.360, that requires how we store our firearms. There's just implications and consequences if we fail to do it in a responsible and safe manner. But the city of Edmonds obviously felt that they knew way more than the state legislature, and they knew how they could save lives. And the way they were going to do that is through a city ordinance that required that when the firearm was not being used or on your person, it had to be locked away. That's right, it had to be locked away. So if you were a single woman living in a condo all by yourself, when you're at home by yourself, you have to lock away your firearm, which, as we know, when they're sitting in gun safes, yes, they are safe, but they're not a very effective self-defense tool at that point. Despite the fact that numerous attorneys had advised the Edmonds City Council that, hey, listen, when you take a look at RCW 9.41.290, the state preemption law, it is pretty obvious that the state has made it clear that they want to control firearms. As a matter of fact, that exact statute reads, the state of Washington hereby fully occupies and preempts the entire field of firearms regulation within the boundaries of the state, including the registration, licensing, possession, purchase, sale, acquisition, transfer, discharge, and transportation of firearms, or any other element relating to firearms or parts thereof, including ammunition and reloader components. Cities, towns, and counties or other municipalities may enact only those laws and ordinances relating to firearms that are specifically authorized by state law, as in 941.300, and are consistent with this chapter. Such local ordinance shall have the same penalty as provided for by state law. Local laws and ordinances that are inconsistent with, more restrictive than, or exceed the requirements of state law shall not be enacted and are preempted and repealed, regardless of the nature of the code, charter, or home rule status of such city, town, county, or municipality. And while I can be very critical of the state legislature for writing word salads all the time that don't make sense, this law makes very clear, at least it would to anyone who understands the English language, that, hey, when it comes to firearm restrictions, only the state's going to get to set that. But no. The city of Edmonds knew better. So they went ahead and passed this ordinance by a vote of 5-1. Only one council member on the city of Edmonds thought, maybe this isn't such a good idea. Well, that law took effect in March of 2019, and almost immediately the petitioner, Mr. Bass, as well as the NRA, sued the city of Edmonds for an injunction to stop this. Just a few months later, in October of 2019, Snohomish County Superior Court Judge Anna Ferris struck the law down as violating state's preemption law. So, that's the end of it, right? Oh, no. Because now the city of Edmonds, yes, the city of Edmonds, appealed that ruling to the Court of Appeals. Now, just a few months later, in February of 2021, the Court of Appeals unanimously, a 3-judge panel unanimously struck the ordinance down again as a clear violation of state preemption law. So, one would think that the city of Edmonds, by now, you're 0 for 2, you lost at the trial level, you lost at the Court of Appeals. You haven't gotten any vote in your favor. The law clearly violates 941-290. So it's time to stop the nonsense, right? Au contraire, because now they petitioned it all the way to the Washington State Supreme Court. Now understand that the Washington State Supreme Court, much like the United States Supreme Court, doesn't have to accept review of anything. They can pick and choose what they're going to hear. But they readily accepted this case. They heard oral argument on it. And by the way, the city of Edmonds, one of the arguments that they're making is that Mr. Bass didn't even have standing to make this challenge, that he had no right to even be challenging this law. And that goes to show, again, some of the arrogance that the city of Edmonds used. Well, in an incredibly decisive and brutal defeat, the city of Edmonds has now been ruled by, on the appellate level, 12-0, because 3 of the 3 judges at the Court of Appeals thumbs down on this law, and all 9 justices at the Washington State Supreme Court also shot this law down. Now, again, I don't mean to get political here, but if anyone knows the political leanings of our state Supreme Court, we know that gun control measures are not particularly disfavored by these justices. This law got rejected by every single judge on the Washington State Supreme Court. Now, I want to give some honorable mention to the cities of Seattle, Walla Walla, Olympia, and my hometown of Kirkland, who joined the city of Edmonds with amicus briefs. Well done. That's a good use of taxpayer resources. To give you an idea of what Justice Gonzalez thought of the city of Edmonds' position, check out these quotes. After reviewing relevant legislative history, this court concludes that the legislature sought to eliminate the multiplicity of local laws relating to firearms and to advance uniformity in criminal firearms regulation, and that the laws and ordinance preempted are laws of application to the general public. And really, they couldn't make it any more clear. Justice Gonzalez went on in ruling in favor for Mr. Bass to state the following. Taken together, these cases establish that RCW 9.41.290 broadly preempts local ordinances that directly regulate firearms themselves, but not necessarily ordinances that have an identical effect on the use and enjoyment of firearm or exercises of municipal authority that do not establish rules of general application to the public. And that's the important thing, because this rule applied to every firearm owner in the city of Edmonds. Therefore, it had a general application to the public, and that's what the Supreme Court went, no, that's what state law preempts. And even though the city of Edmonds tried to argue that they could regulate certain portions of firearm activities that were not within the state preemption law, Justice Gonzalez shot that down as follows. We decline to limit the preemption statute to firearms transactions and active use. The limitation is simply not consistent with the words of the statute as a whole. And that's the point I'm trying to make, is that the words of this statute could not be any more clear. Justice Gonzalez further stated, under the statute, the state of Washington hereby fully occupies and preempts the entire field of firearms regulations. The key question is whether the ordinance regulates firearms, not whether it regulates firearms transactions or active use. And there again, you can see that if we are allowing local, municipal, county, city governments to regulate firearms in any way, that is a violation of 941-290. That's a violation of state preemption law. And that uniformity of laws throughout the state is exactly the purpose that we have 941-290. Now, I've been in the criminal justice system for about 22, 23 years now, and I know what it takes to get a case all the way to the Washington State Supreme Court. And it takes a lot of time. It takes a lot of energy. It takes a lot of lawyers. And you know what else it takes? It takes a lot of money. And the city of Edmonds did all of this on the taxpayer's dime. They knew when they drafted that legislation back in 2018 that it was unconstitutional. They were told before they passed the legislation that it was unconstitutional, yet they passed it 5-1 anyways. They were immediately told by a court in their own county by a trial judge that, hey, this law violates 941-290. What did they do? They appealed it. They had 3 judges which reviewed it, and unanimously they struck it down, only to take it to the Washington State Supreme Court to have it struck down again, this time 9-0. Candidly, Edmonds, you owe your citizens some money back. This was a futile effort, and candidly, under the rules of professional conduct, there are rules that prohibit lawyers from signing pleadings and documents where they know the law to be to the contrary. Listen, you may have more questions about the city of Edmonds or any of these other ridiculous municipal gun ordinances, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.